So we actually have a team from Central, from Office of General Counsel here today. Jessica Morak is going to be speaking about the sexual attestation policy, and we have Lucrece Francois, who I believe was having some video trouble, but should be in the meeting and is going to answer some further questions on NIL and speak to the what's going on with the transgender student athletes. So I had the privilege of speaking with you all last year with regards to the name, image, and likeness legislation, or lack thereof, after the NCAA had changed their rules on that issue. It has been a very busy year as far as legal issues and compliance issues with regards to NCAA, as NCAA and NJCAA athletics, as you all know. I am pleased to announce that Cuny now officially has at least an interim name, image, and likeness policy that has been passed and is in effect. It will be disseminated to you all either by websites, or I'm working with Joseph in CUNYAC to make sure that you all get a copy of it. It was passed by the board. I believe it was last month or 2 months ago. New York still has not passed their law with regards to name, image, and likeness. It has cleared the House, it's cleared the Assembly, and it has cleared the Senate, and it is now going to be sent over to the governor's office for signature. But that has not happened yet. When that happens, we will probably amend our policy slightly, only because right now it says that it's an interim pending any legislation that is passed. That being said, we have aligned our policy with the legislation that was proposed, so I don't think there will be any substantive changes with regards to name, image, and likeness. Now, what does that mean for you as coaches? My little spiel to you all is going to be slightly different than what I spoke to the students about earlier today. With the students, we really focused on the details of the policy, the types of things that they are not allowed to do, because pretty much it's one of those policies that you're allowed to make contracts with name, image, and likeness for purposes of name, image, and likeness, except for these types of things. And those types of things are pretty self-explanatory. No drug, nothing that promotes drugs, nothing that promotes alcohol, nothing that would interfere with their ability to be an athlete. So nothing during team practices, nothing during competitions, nothing that would involve CUNY branded gear, nothing that would be a program that would be an opposite to something that we have a sponsorship for. So the big one at the university is we have a contract with Pepsi. So a student athlete wouldn't be able to take a name, image, and likeness opportunity from Coke and possibly from another competitor, any other competitor with PepsiCo. There might be some individual ones at your campuses, but those will be done on a case by, everything is addressed on a case-by-case basis, and the students have a form that they will be filling out. Now, what do you have to know as coaches? I'm going to just quickly share my screen. All right. So this is the actual policy. It is going to eventually be found in online in the Manual of General Policy 7.071. And that's where it's going to live. So eventually this will be up on the main CUNY website, and you will see the entire protocol listed there. Now it is written, I would definitely encourage you to get familiar with this in case you have get any questions from your student athletes. It looks a little complicated at first, but it is actually pretty self-explanatory and written pretty cleanly in plain English as far as what they're allowed to do and what they're not allowed to do. Students are allowed to have agents, advisors, and attorneys, but only for NIL actions and activities, not for anything related to their participation with sports. Now, what is important to remember for coaches is that we must stay away from pay for play and impermissible inducements. That is a recipe for disaster. So what does that mean for you? What that means is that as far as pay for play, there can be nothing that we do not want any compensation for athletic participation or achievement. The athletic performance may enhance a student athlete's NIL value, but athletic performance may not be consideration for NIL compensation. So in other words, they cannot get paid to play, all right? Or they cannot get paid with anything related to their actual participation in athletics. The second thing, and what I think it would be more prescient for coaches, is no impermissible inducements. So NIL, name, image, and likeness compensation cannot be contingent on enrollment or on at a particular school. But taking that a little bit further, for you as coaches, that means that you cannot get NIL opportunities for your students, your student athletes. That is going to be a slippery slope and a recipe for disaster. So you can't say, hey, I have this opportunity, for you. That can be viewed as an impermissible inducements or a pay to play. Just don't go there. This is something that they have to do on their own, that they should find the opportunities they should find themselves. For those of you in Division II, NIL can't be used as an inducement to for recruitment. So you can't say, hey, if you come to Cuny, we have this opportunity for you. CUNY is going to set you up with an NIL opportunity. Can't do it, no go. The fact of the matter is living in New York should be, should make it clear to the student athletes that, New York itself is has many opportunities for name, image, and likeness contracts, but you are not their agent. You are not, you shouldn't be acting on their behalf. You shouldn't be sending them opportunities, and certainly not using it as any sort of an inducement to say, hey, if you play on my volleyball team or play on my soccer team, we're gonna, I'm gonna be able to hook you up with NIL opportunities. Don't do it. Bad idea. Major no-no. So that's the basics on name, image, and likeness. Like I said, the policy itself is going to be available on the website when the website is updated. We'll make sure it gets disseminated. I'll speak to Joseph and Kim, and we'll take care of that. With regards, if any student says, hey, comes up to you and says, hey, I have this opportunity, I don't know how to get it approved, tell them to consult the policy, but I will show you the form that will be most likely on CUNY's website somewhere, possibly on individual schools' websites, so that you can see it. It looks like this. It's the CUNY form for reporting name, image, and likeness contracts. It gets emailed to our office in the Office of General Counsel. We encourage them to email it as quickly as possible so that we can approve it. We are not going to opine on whether it's a good contract or a bad contract, whether they should sign it, whether they shouldn't sign it, whether it's a good idea or a bad idea. All we're doing is going to evaluate what the contract, the substance of the contract is, and make sure that it doesn't fall under any of those categories that are impermissible. So for example, checking if it's with a clothing company or something like that, we probably will check to see if there's any sponsorships that the college or CUNYAC or the university has that would be a competitor to that. If it's an alcohol company or a bar or an adult entertainment industry or something like that, and you'll see these are all outlined specifically. Those will be the type of thing that we will object and tell them that we can't, that's not permissible in the policy. But it is up to the student athlete to make sure that they understand what the policy is, and to make sure that what they're signing up for complies in that. This is more to report it to us so that we can, either help guide them as much as we are allowed to by the NCAA and NJCAA, and to give them a little guidance in that regards. So this is what the form looks like. You can sign it electronically or print it out and sign it, and then email it to OGC. So that is what I have for you on name, image, and likeness. I'm just looking at the chat. I don't see any questions. Are there any questions with regards to this? Okay. All right, not seeing anything. I'm going to send this over to my colleague, Lucrece.
Speaking of images, I apologize. It seems that either I can allow you guys to see my face or I can speak with you guys. My computer's not allowing me to do both right now. I think that my voice is actually more beneficial to you than my image at this point. Just very briefly, we wanted to let you know that we are aware that guidance is needed on as with respect to transgender student athletes. And CUNY we're committed to our to diversity and non-discrimination, and we are currently working on our policy regarding transgender student athletes. At this moment, at the NJCAA level, pending further guidance and the finalizing of our policy, we will be making decisions on a case-by-case basis. So any questions that arise can be brought to OGC until the policy is in place. I don't think there are any questions at this point because, as I mentioned, the policy is still in its developmental stages. So I'm just going to pass this back to Todd or over to Jessica Morak, who will speak on the additional attestations that need to be made by the athletes. Jessica?
Yep, that's me. Thanks so much, Lucrece. So hi, everybody. I'm Jessica Morak. I am an Associate General Counsel in the General Counsel's Office, and I'm here to talk to you today about the Student Athlete Attestation of Serious Misconduct Policy, which is a mouthful. And yes, we did try and think of other names and noticed we didn't think of any, and this is what we came up with, and I do apologize for it. So this is a new policy, and as you know, everyone loves a new policy because everyone doesn't know how it works and there's lots of confusion. And this isn't really any exception, but we're here to help. We're here to explain. We want to help everyone. And so this is going to be probably your first introduction to it, but certainly not your last. So I'm going to start with just an overview of the policy, what it is, who it affects, and then I'm going to end with some special considerations for coaches. A lot of what's going on in this policy actually will not involve coaches. There's many other people that are going to have a role in this policy. Coaches are not actually one of them, and there are specific reasons for that. But obviously, it will be affecting your athletes, and so your student athletes. So it is very important that you're familiar with the policy. So as I said, it's a new policy, and we expect it to be adopted by the Board of Trustees possibly next week, and it will then be up to each campus to implement it. Some background. This was necessitated by CUNY's membership in the NCAA. The NCAA, as many of you may know, has its own policy on campus sexual violence, and that was first adopted in 2017 and was revised in 2021. It now requires additional obligations of NCAA member institutions like CUNY. Beginning with this year, this academic year, 2022 to 2023, these new obligations require student athletes to attest annually whether they have been subjected to prior discipline or a conviction for what we are terming serious misconduct, and I'm going to go through in a minute what that means. It also obligates CUNY to take reasonable steps to confirm the information that's provided by the student. And the way that this is going to happen is the student is going to fill out what we are calling the attestation form. Once we are provided, we are obligated to take appropriate action. And we are also obligated to maintain a written procedure that specifically directs athletic staff to adhere to this policy and procedure. And we've done that. So let's start with who. Who does this apply to? It's going to apply to all student athletes participating in intercollegiate athletics at CUNY. So that means NCAA and NJCAA. CUNY made the decision to apply this uniformly to all student athletes, whether or not you're participating in NCAA sports or NJCAA sports, even though it originated as an NCAA compliance issue. This covers incoming students, transfer students, and currently matriculated students. Let's talk about what. What do student athletes actually have to disclose? What are they obligated to disclose? Well, they're obligated to disclose whether they have been disciplined through a campus misconduct proceeding for serious misconduct. And these are all definitions that are specified in the policy. They also must attest whether or not they've ever been convicted of, pled guilty to, or pled no contest to any crime of serious misconduct. Third, there is the last category of information. This is only for transfer students. Specifically asks whether or not the transfer student at the time of the transfer or separation from their most recently attended institution, whether there was a campus misconduct proceeding involving serious misconduct that was incomplete or pending at the time of the transfer. So those are the three buckets that we're talking about. That's the three categories of information that's included on the attestation form. Now, they must disclose all either convictions or prior discipline, including high school and through the present, right? So it's not just higher education. It does include any serious misconduct that resulted in either discipline or conviction that happened in high school as well. Now, serious misconduct. This is an umbrella term that includes what we have defined, which are defined in the policy as three sort of different categories of conduct. Some of them come from the NCAA policy. Some of them come from our own policy on sexual misconduct. So we have a category of sexual misconduct, which includes the definition of sexual violence promulgated by the NCAA, as well as the additional conduct that is prohibited under our policy on sexual misconduct. That all comes in as this category of sexual misconduct. There's also interpersonal violence, which sounds a lot like dating violence, and in fact is a lot like dating violence, but it's a bit different, and it's also defined in the policy. It comes from the NCAA Board of Governors Campus Sexual Violence Policy. And the last is a category called other acts of violence, which is also defined in the policy, comes from the NCAA Campus Sexual Violence Policy, and really gets at crimes that are very serious, like murder or assault or manslaughter. So hopefully we won't have a number of those, but that's what's sort of defined in the policy. What do students have to, we've already discussed what students must disclose. What should they not be disclosing? This is all explained in the policy, and we plan on having info sessions with the students to explain this to them in more detail, but we're sort of giving you a high level overview. They're not going to be disclosing things like a sealed conviction, right? Somewhere where they were determined not responsible at a prior institution or found not guilty. Potentially, unless they are a transfer student, we're going to talk about that a little bit later because they're a little bit different. They don't have to disclose if they were just under investigation by a prior campus or law enforcement entity, right? An arrest alone, that's not going to be disclosed. It is very, very specifically only a finding or discipline, which was defined as basically a finding of responsibility by a campus or a conviction. So It's a lot of information, but it actually is a very small amount or a small bucket of information that should be disclosed. So I want to just share my screen for a minute to show a little flow chart that we made. It's pretty basic, so it's certainly not going to go through the entire policy, but just giving you an overview of sort of what we're talking about here. Okay, so we start with the student attestation. Was there a disclosure made, right? Because all incoming students are going to be filling this out, all transfer students, and all currently matriculated students will be having to fill this out on an annual basis, okay? So this is an annual obligation. If the student does not make a disclosure, they may participate. If a disclosure is made, that's when we really get into this process. And we go, the process has basically two different main areas and then potentially a third at the end. The first is called the due diligence review. And this requires a person who's designated in the athletics office, not going to be coaches, but someone designated by the athletics office who will basically, once they receive that disclosure, will have to take reasonable steps to confirm the information. Okay. Additionally, a student may actually submit information along with the attestation form about the conviction or the discipline, and that will also be considered. There's a pretty lengthy process involved in the due diligence review, which I'm not going to go over too much here because it won't involve you. But needless to say, there are steps that this individual who's going to be designated to undergo this process must take to reasonably confirm the information. Once the information is received, it's going to go to the campus level review committee, which is going to be staffed at the campus level, first by the Title IX coordinator. This is who the committee is going to be. The Title IX coordinator, the student conduct officer, and the CUNYAC associate commissioner, who I know is on today. That will be true for all schools except for our Division II schools who are going to nominate a person to be on that that campus level review panel. The eligibility commission or committee will then decide whether or not that student is eligible to participate in intercollegiate athletics. And we do sort of have been, and we have been giving guidance to the folks going to be on this panel that we want everyone to sort of come in with a viewpoint towards participation. That's what we're looking for. We're looking towards participation and not towards ineligibility. So there's options of what the committee might determine. Maybe the student is eligible to participate. Perhaps based on what was disclosed, they might be subject to a period of suspension, or potentially, and hopefully this won't be the case for most, they may be deemed permanently ineligible. Once a determination of ineligibility, either for a period of suspension or a lifetime ban, is made, the student will also be given the opportunity to appeal. So I want to just talk to you all a little bit about where the coaches come in, okay? Student privacy must be our priority in this process. We're dealing with very, very sensitive information. And so information gathered during this process will not be disclosed to fellow students, teammates, or coaches until and unless a certain point, which I'm about to tell you about. Coaches will not be informed about this until and unless the student is deemed ineligible to participate for a period or for a lifetime ban. But otherwise, the coach will not be, you as coaches will not be aware that a student has made a disclosure until such time that they are deemed ineligible to participate. And that is really to protect student privacy until such time that until and unless we no longer have the ability to do so. Some other things I want to sort of make clear to you as coaches is that for this first year, due to the timing of when we are rolling out this policy, for this year only, during, oh, sorry. I'm going to keep going. During this process, students will be able to participate while that that due diligence and eligibility review, if we get to that point, is going on. Starting with the spring 2023, that will no longer be the case. A student must fully complete this entire process. The attestation must be collected, and if there is a disclosure, there must be a due diligence review and an eligibility review with a determination before the student can participate. The last thing I want to talk to you about is transfer students. Transfer students are a little bit different in that the NCAA has a bit more obligations for them. And so with respect to transfer students, for transfer students, CUNY will have to take reasonable steps to confirm this information, regardless of whether the student makes a disclosure. And that's because the NCAA was very, very concerned about transfer students who may leave an institution with a pending or open campus misconduct proceeding. That was really what the goal was. So for incoming students who are not transfer students, they will be given an attestation form, and they will only have to disclose. They will make a disclosure or not. For transfer students, and that will be the end. If there's no disclosure, there's no more steps to take. For transfer students, there are steps to be taken, regardless of whether or not a disclosure is made. And then for current students who have come back their second year, everyone's going to have to fill out an attestation form every year, but hopefully won't have anything to attest to because you've already done that. You won't have to attest to something you've already done in a previous attestation. There is a thing in the policy about mid-year attestation. So if between attestation periods something happens, but those are sort of rare, and basically they have to tell you as soon as practicable. But again, that's only if they're found responsible or convicted. It's not if an investigation is just ongoing. So I know that was a lot of information. I'm going to look in the chat. I don't see any questions, which I find very odd because I'm not sure that I actually spoke anything that was coherent English just now. But I'll stay on for a minute, and if something comes to everyone, pop it in the chat.
Feel free to unmute if you have any questions. You guys can unmute yourselves.
Looks like there might be a question from someone logged in as Moto G7 Plus.
Yes, I just asked to unmute.
Oh, can you hear me?
Yes.
I have a question. What prevents someone from not telling the truth? Say that way, I've had no incidents, whether they might have had an incident. How do you prove that?
So the truth is that we really can't. We're taking for incoming students and our returning students, we are required to ask students to attest, but that's really the obligation. For transfer students, the onus is actually on CUNY to go and to reasonably confirm that there wasn't anything pending at the school at the time. So we're taking the position that which is what we're entitled, which is what we're required to do, that our students have to attest. There is obviously a penalty that they can face if for some reason we find out that they intentionally gave false information. They can be subject to disciplinary action along with suspension from athletics, and hopefully we won't have to deal with that.
Obviously, I do have a question, but isn't this basic question asking violating their privacy?
So great question. There's actually some exceptions to the FERPA law that may actually get at some of this, but regardless, on the attestation, they will be asked to sign a FERPA release. So we are going to be asking them to sign a FERPA release so that we can ask these questions, because it is a requirement of the NCAA. Again, participating in intercollegiate athletics is a privilege. And so we have to, in order to be compliant with this organization, this is the information we need to have. And so if a student wants to be in intercollegiate athletics, they will have to sign this FERPA release for this information. So we're taking that approach to it, but you won't see this probably, but there are schools that are already sending these attestation forms, and some of them do not have the FERPA release because there are some exceptions to that, but we're going to have everyone sign a release.
Okay, thank you.
Obviously, this is one additional requirement on top of everything else that the students have been asked to do previously. The Spark training will still be in place. This is over and above that based upon the latest NCAA guidance. And then obviously the sickle cell waiver was another NCAA requirement for this academic year moving forward. So certainly I've expressed that to administration in terms of the administrative burden that's falling not just on the students, but also on the departments. And obviously, until we navigate this process for the first time, only then we'll really be able to get a better sense of the impact on student participation and navigating these logistics. But certainly where our numbers have been a challenge coming off the pandemic, this potentially could be another hurdle. But ultimately, we'll do everything we can to support the campuses and address any questions or concerns that students may have in navigating this.
You may have said this, but
Oh, sorry. I see there's
Are
a
these
question
form-
from,
Oh,
oh, sorry,
sorry.
from Christy Herring raised her hand first, I think.
I just wanted to ask, how does this affect the incoming freshmen who are not of age to sign a legal document?
Great question also. This crew has great questions. So actually we have on the release for anyone who's under age of 18 will have a parent guardian sign.
And that same box, by the way, appears on the NIL form as well.
And that's consistent with the NCAA documentation and the other forms that the students need to sign.
Any other questions?
you may have said this, forgive me if you have, but are these forms coming through ARMed? Are they going directly to them at home, or how are they getting these attestation forms?
That's actually a great question. I believe that we're going to be leaving it up to the campuses to distribute them. I know that there are other compliance documents that are sent out by the athletics. I've seen sort of some of them. But so we're going to be asking, we're sort of leaving it up to each athletics office to do that as they may, but we have asked each, part of the policy in our implementation memo has asked each campus to designate a specific person, the campus attestation designee. That's what we're calling them. I'm not sure if anyone's going to like that name, but that's what we're giving them, their moniker. They will sort of be in charge of collecting and very likely distributing these documents to the students. And so each campus will be able to designate that person. I know that some of the colleges have like a compliance officer and some do not. So those who do not will have to designate someone, but that will probably be the person who's going to be distributing that. Again, when this has happened, I mean, we want of each different sports timeline, right? And the fact that this process needs to take place, the entirety of it, before someone can participate, with the exception of this semester. So whenever the campus wants to give it out as early as they want to, they can, just making sure that, it's collected in a timely manner for your team.
We had some discussion on the planning meetings in regards to potentially ways in which we can streamline this moving forward. Obviously, the timeline we're dealing with right now is less than ideal, but if this could be over time turned into an electronic process and or possibly coordinated in conjunction with the Spark training, where it could be a step process from there. That's just not possible at this juncture, but that's something we'll continue to look into.
Jessica, there's two more questions in the chat. Well, one came directly to me. I'll ask the one. It says, what if a student athlete who's under the age of consent and the parent or guardian refuses to sign?
So I think we would have to talk to that parent, because without this attestation, that student will not be able to participate in intercollegiate athletics. We have to be able to, in order to be compliant with NCAA, we have to be able to attest that we have given these documents to the students and they have made this attestation. Without, they will not be able to participate in intercollegiate athletics, unfortunately.
Until they turn 18, until they're able to sign themselves, potentially.
Okay, and the next question was, won't this be exposing the student athletes to double jeopardy if they previously have had an incident and paid the penalty?
Great question. Absolutely not, not whatsoever. So something I didn't mention is that these you guys really are on your game with the questions. These disclosures will not at all affect enrollment or admission. So these, again, we're going to be keeping these very, very, very private. Now, in terms of having an additional penalty, right, like not being able to participate in intercollegiate athletics, a little bit differently, because they have actually, this is actually a privilege, and it is really a requirement from the NCAA. So it's a privilege to not be able to be able to participate in intercollegiate athletics, which can be taken away. Now, I will also say that we are giving guidance to the campus review panels about considerations and factors when they're making those determinations. And again, we're coming from the viewpoint of encouraging participation, right? That, like, we want to start at the base level of, we want the student to be able to pay sports, but are there factors that are going to get us over the line? And we've given we're giving some guidance. We haven't done our trainings yet, but we will be giving guidance on sort of what things they should be considering. Like, how long ago was this? Are there any mitigating factors happening? Are there any mitigating factors that we can say, have there been any programming since then that are happening or going to, affect that student's ability? Maybe they've done a ton of like sexual assault or sexual harassment or gender-based harassment programming after. Maybe this was 10 years ago. Maybe they've done all of these good work since. Things that we can consider in making that eligibility determination.
So I see there was the question from Jeff Narenberg. How many lawsuits do you expect this year?
I expect none.
Look, again, as Jessica said, this is sort of a fiat that we were given from, this was a command we were given from the NCAA. So it's not like it's something that CUNY has come up with or CUNY is alone with.
Not at all.
In the country. Yeah.
Right. It's not even something that CUNY necessarily is, endorsing. But this is what we have to do. And to be honest, we're hopeful that this will be the exception and not the rule, and that there will be not as many disclosures. But I will tell you, we're already starting to get attestation forms from other schools. This should have, we're implementing this now, and hopefully we'll see, we're going to see how it goes, but it came from the NCAA and our hands are kind of tied.
Yeah. And of course, if there are any issues with it, if there are anything that goes to litigation or whatnot, obviously we are, we'll be here to, we'll handle it the same way that we handle any other disputes and litigations that arise throughout the CUNY system. So. And as Jessica said, there's going to be formal guidance that's going to be forthcoming, implementation memo, I believe, as well as trainings that are going to be given to all of the stakeholders that are involved in this.
One thing I should also say is that we have encouraged, and it's in the implementation memo, we've encouraged each campus to identify a confidential resource that the students can go to ask questions about the form and how to fill out the form. So we are encouraging campuses to identify a person who can be there as a support on the ground to the students.
Kelly Poloquin asked, the same requirements at the NCAA level will apply to the NJCAA 2-year level. And as Jessica said earlier, CUNY has made the decision to apply this universally. So yes, the answer to that is yes. NIL also, we are applying universally. NCAA gave more guidance than the NJCAA on it, but it is NJCAA said it was permissible. And so that also, much like the concussion protocols, is something that is universal, CUNY-wide.
Hi, I have a question. Is this more like something that you guys just doing because prevention, or this is because this is happening and you guys want to do something about it?
I'm not sure I totally understand the question, but I can tell you that the policy, and maybe I'm answering, the policy is being implemented because the NCAA requires it.
Yeah, this is not being implemented in reaction to
Anything
a problem that we have found specifically at CUNY, or because we've gotten 15 complaints about something. This is not. This is fully something that is being that is a nationwide NCAA requirement. So it may be in response to issues that other schools have had or the NCAA has had, but it's certainly not something that is being implemented because of anything CUNY specific. This is an NCAA policy that addresses every NCAA participating institution nationwide.
Thank you. Yeah, that's what I asked. Thank you.
Good questions. Really good questions. All right.
And question, can you hear me?
Yes.
The issue happened overseas.
I'm so sorry. Could you say them again?
What if an issue happened out of the country?
So it's interesting, actually. The way that the NCAA policy is written, it actually just says the last institution that you attended or conviction, right? And so if a student was, at a institution overseas, right, there's nothing, I don't believe there's anything in the campus sexual violence policy from the NCAA that limits it to the US, unlike the Title IX regulations currently. So, how much headway we'll actually be able to get with overseas, that's a different question. And we have discussed internally what sort of reasonable steps constitutes, right? What constitutes reasonable steps and how sort of far you have to go. But since this group's not going to be doing that, I'm not going to get too much into it. But suffice to say, I don't believe there's any requirement that it has to have happened in the US. I think this is actually addressed in our FAQs, which I didn't mention. We're making FAQs both for faculty, staff, and students. And I do believe that's actually one of the questions we address in there.
Why don't y'all just do background checks of every student? I mean, that's what it sounds like.
So actually, we don't want to have to do that. We have to have an attestation. It's required. And in fact, if there's nothing made or disclosed, we don't have to look any further. In fact, we're not going to look any further. We're just doing what the NCAA is requiring us to do. Now, if there is something disclosed that we might have to take reasonable steps to confirm, of course, there's going to do that. But that's why student privacy has been absolutely prioritized during this policy, which is why only those on a need-to-know basis will be disclosed, because obviously this information is very sensitive, but we want to be able to receive funding from the NCAA. And without this policy, we are at risk of losing that.
And at risk of losing our ability to participate.
Right.
So does this policy just affect students, or does it affect coaches, ADs? It should affect everybody if that's the case.
The policy only affects students who are participating in covered student athletes who are participating in intercollegiate athletics. So a incoming student, a transfer student who's seeking to participate, or a current student. That's the only people that are applied to this policy, because that's the only thing the NCAA is requiring.
So if a student did something dopey in high school or even as a freshman, and whatever happened, the incident was reported, it was dealt with, the student paid the price, whatever that was. Now he's an enrolled student. The college has no problem with him being there. The coach has no problem with him being there. The NCAA might take action anyway to prevent this student from participating.
Well, the
But it just seems
NCAA,
like they're-
oh, sorry.
it just seems like they're trying to build the database of information that, you know.
Let's be clear, sorry. The NCAA will not be making the determinations, nor will they have access to the information that's disclosed. Panels on the campus level will make the determination. It will not be made by the NCAA. So each campus will have a campus review panel that will then review the information and make an eligibility determination. And again, we'll be considering factors like how long ago did this happen? You know, what was the sanction, if any? And again, we're only talking about this conduct that constitutes serious misconduct, which is actually a smaller bucket of information than you might be thinking about. Secondly, that resulted in discipline or a conviction. So not just that, you know, they were under investigation and it went nowhere, or that they were found not responsible. That is not what should be disclosed. It is only those small buckets. And then our campus level review panel, which is not going to be disclosing or sharing this information with anyone other than the panel until such time that an ineligibility determination is rendered, will determine if that student is eligible to participate in sports. And again, with the mindset, with the hope, with the viewpoint that they can participate. That is what we are giving the instruction or the guidance is. That's the goal. We certainly want to have that in our head, the viewpoint of being able to participate, but are there those factors that will have to allow for, you know, will tip it over. At the end of the day, though, this was something that we had to implement because of an NCAA rule. Our hands are completely tied, and we do not want to not be able to have NCAA sports.
All right, one more question. We have to wrap this section up, but one more question. Go ahead, Mike.
You have a question. These at the campus level, these review boards, what is the policy and procedure, and what is the review timeline for these issues if they are raised?
So there aren't specific timelines for them because we understand that there might be some issues getting information, and also each case is different. But obviously, you know, we are going to be giving best practices guidance to the folks that are going to be on the campus review panel, and sort of, you know, indicating if you've made this many attempts to get the information, real attempts, and it hasn't gone anywhere, let's keep proceeding. And we're trying to have, you know, unless if it's a pretty straightforward case, you know, we want these sort of to be 1 to 2 weeks, hopefully, so that we're not having someone sit out for a very lengthy amount of time. It's scary to put, we don't like to put specific timelines on these because of course each case is different and could have different facts. So we don't want to sort of limit that, especially because we haven't seen this before. But obviously we're trying to work as expeditiously as possible so that a student can, if they're going to be deemed eligible to participate.
So okay, and I guess the follow-up for that would be, what is stopping someone from being a whistleblower, even if it's going nowhere? So let's just say kid X is a point guard at institution Y, and that kid is supposed to play in a championship game tonight. He's the best player, and someone doesn't want him to play, and that whistle is blown. How do you guys determine whether or not that is something that makes that kid sit out that night, or needs to be the review panel ASAP?
So again, this is only for if someone has made a disclosure on an attestation form of discipline or a conviction. So everyone's going to have to annually attest. If we're talking about like something happening that, you know, day, like they've just gotten accused of something, that is not going to.
I guess where I was going with, let's say a kid, you know, does happen. Let's just say this is all truth here. I'm just throwing out a scenario. Let's say the kid lied on his attestation. Someone knew about that, but didn't want to really drop a dime on that kid until it was really needed. What happens then at the review board level? And let's just say that doesn't happen. Let's just say it's all hearsay. They don't want the kid to play. How are you going to sift through that to make sure that the kid still can play even if someone calls again. And I'm kind of looking at it from a logistical standpoint of how people would use this for malice, right? Because the kid could potentially impact the game, but they want to be able to drop this information so the kid doesn't play. And I'm not saying that that's going to happen this year, but I'm saying that that's something that could potentially happen. And now that kid sits out because someone says, no, he lied on his attestation. You need to look into him because he did this X, and all of that's not truthful at all.
I mean, we're going to have to take those. We're going to have to take those as they come. I'm hoping that that will not happen, but we did solicit feedback from the athletic directors about whether or not, you know, there was a decision made that when this process is pending, that the person should not be able to participate. Obviously, if the person did not attest to that, you know, I would not want to take that at face value that we're getting that not from the student themselves, especially because we're putting the onus on the student. You would want to take a look at what is being said, you know, but specifically, we need to have a specific disclosure of very specific things, right? Discipline or conviction. But there is going to be a certain level of discretion that's left up to the campus athletic squads and the athletic departments that will have to be made a judgment call about whether or not that person will be deemed ineligible. You know, if we have a specific person saying this person was convicted of rape, perhaps that's going to be one where they're going to say, okay, at this point, you're not going to participate until we do an eligibility review. Part of this is going to be at the discretion of the campus review panels, because again, these are NCAA policies. But you know, this hasn't come into fruition yet. We're going to have to see how it plays out. I'm hopeful that that will not happen, but we're going to have to take these as they come.
And also to follow up on that, as an example, the example that you just gave also presupposes that the student athlete lied on their form. Obviously, if the student athlete was truthful at the time that they filled out the attestation form, this issue would have been completely flushed out before you get to that championship game, and before, you know, way before that. So while I and obviously whether someone lies on the attestation form or not, that's going to have potential disciplinary, student disciplinary issues related to that as well, because the same way as if they had lied on their application to get into CUNY, right? Or created a false transcript. I mean, being truthful here is the bare minimum, right? So, you know, while obviously we hope that a situation like that isn't going to occur, and obviously something like that would significantly hurt the team that they were on. Again, it presupposes that the student lied initially. So the way to avoid that is the students should be truthful. If they're truthful, then any issues that they possibly will have will be completely flushed out, and they won't have to worry about what if somebody reports me and things like that. You know, and it's you know, the onus is on them to be truthful, and we expect all CUNY students to be truthful on forms that they have to attest to. It's a it's a good lesson going forward. But this is you know, again, this is something that the NCAA has what the NCAA is requiring us to do. And furthermore, as Jessica said, and I think is worth reiterating, you know, declaring somebody ineligible to participate in student athletics that's the nuclear option, right? That's the worst case, highest possible penalty. There are a whole lot of steps before you get to that situation. And this, you know, so that's what it is. But candor on forms is, you know, you fill out a license application and you have to swear that everything is true, or a passport, you have to swear everything is true. So being truthful on forms is par for the course.